All right, if you're deep into your CA foundation studies, you know that special contracts can feel a little overwhelming. But don't you worry. Today, we are going to zero in on two of the most critical concepts you'll come across: indemnity and guarantee. Let's really nail these down so you can walk into your exams feeling confident. So, here's our game plan for today. We're going to start with why these contracts even exist. Then, we'll dive into what indemnity and guarantee actually are, put them side by side to see the differences, and wrap up with a super important topic for your exams: how a guarantor can get off the hook. You know, this is really the big question, isn't it? In the business world, a simple handshake or a promise just doesn't cut it. It's risky. So, how do you add some legal muscle to back it up? Well, the Indian Contract Act of 1872 gives us two really powerful tools for just that, and we're about to break them down. Okay, let's jump into our first solution: the contract of indemnity. The easiest way to think about this one is like a simple two-person safety net. It's a direct promise from one person to another saying, hey, if you suffer a loss, I've got your back. So the act itself gives us the official definition, and it's pretty clear. The key phrase you've got to lock into your brain is to save the other from loss. That's the whole point. This contract is all about one thing: compensating someone after they've taken a hit. It's a promise to make them whole again. And the setup? It really couldn't be any simpler. You've got two people. First, the indemnifier. That's the person making the promise. And second, the indemnified. That's the person being protected. That's it. Just a straight line of defense against a potential loss. See how this works? The trigger is the event. The tree falls, and boom, there's a loss. That's the exact moment when the indemnifier, X, has to step up and pay for that fence. Their liability is primary, it's direct. No one else is involved in this little arrangement. Okay, let's switch gears to our second contract. This is where things get a little more interesting, a little more complex. We're moving from a simple two-way street to what you can think of as a three-party web: the contract of guarantee. Now, listen to the wording here, because it reveals a huge difference. Unlike indemnity, which is about any old loss, this contract only kicks in on the default of a third person. That means someone else has to fail to do what they promised first. And here are our three key players in this web. You've got the principal debtor. This is the person who owes the main debt. Then you have the creditor, who is owed the money. And finally, the surety. Think of them as the hero who steps in and gives the guarantee. Getting these three parties straight is a guaranteed mark on your exam. And this right here is the main takeaway. The surety is the backup plan. The creditor has to try and get their money from the principal debtor first. The surety's responsibility is secondary. It only activates if and only if the debtor defaults. This is what makes a loan or a promise so much safer for the creditor. All right, now for the fun part. Let's put these two contracts head to head. Being able to clearly explain the difference between indemnity and guarantee is a classic exam question, so this is where you really want to pay attention. This table just breaks it all down so nicely. You can see the differences in the number of parties, in the purpose. But look, if you only remember one thing from this comparison, please make it the nature of liability. Indemnity is primary. It's the main promise. A guarantee is secondary. It's a backup promise. That single distinction is the absolute key. So, is a surety on the hook forever? Not at all. There are very specific situations where their legal duty just vanishes. Let's go through the three main ways a surety can be discharged or let off the hook from their liability. To make this super easy to remember, just think of these as three different escape routes. The surety can actively back out, the creditor can accidentally do something that lets them off the hook, or it turns out the original contract was flawed from the very beginning. First up, revocation. This is where the guarantee is actively canceled, but only for things that happen in the future. So for an ongoing guarantee, a surety can give notice and say, I'm out, or something like their death can automatically do it. But the key word here is future. They're still responsible for any debts that piled up before they revoked it. Second, the creditor's own actions can free the surety. Think of it like this. The surety guaranteed a very specific deal. If the creditor changes that deal in any significant way, maybe they alter the terms or give the debtor more time to pay, without getting the surety's permission, then the guarantee is off. You just can't change the rules of the game halfway through. And finally, a guarantee is just plain invalid if it wasn't made in good faith. You know, if the creditor lied or hid some really important facts just to get the surety to sign on the dotted line, The law says that contract was never really valid to begin with. It can't be enforced. So, if you take away just one thing from this whole explainer for your studies, let it be this. Indemnity, 2 people covering a loss. Guarantee, 3 people securing a debt. It's all about the purpose and the number of players. Get that straight, and you're golden. Okay, let's end with a little brain teaser, a classic exam-style curveball. If the main debtor is a minor and you can't sue them, can the creditor just go straight to the surety for the money? The answer is a little tricky, and it all boils down to the exact nature of the surety's liability. Think that one through, and good luck with your studies.